Act. And we have said that in our recommendations to Parliament, the Joint Select Committee and this committee, in terms of a proposal to have this amended, it's too wide. We understand that there must be a balance. Some things must be considered sensitive and confidential and kept that way. But this goes too far, and we have submitted that. So it now comes to the question as to, opinions. Now, as you go through this piece of legislation, as all of us had, and I've found innumerable instances of what you call conflicts of law. I lectured law for 10 years. And it's not unusual for pieces of legislation to have clear conflicts of law. And Mr. Chairman, this is perhaps one of the reasons why it's very important to have this process and the Joint Select Committee process, where we review the legislation to identify those possible conflicts, where you're looking at things that this could never be. You pointed out one earlier, Section 6.3a, which says that the Commission shall not be subject to the direction of any authority. And I gather that someone else on that side is saying something else. These are clear conflicts. Yes, same act. And so it's important that these things are brought to light. And the Parliament, through you and discussion with us, given an opportunity to review them and decide exactly what is it that Parliament wants, and then to amend the law. You're going to have conflicted interpretations. We've heard one, that sort of thing. But I think these are provisions which are ripe for consideration, and they are ripe for review and amendment, for Parliament to reflect actually what it is that they want. But as our chairman said, we believe in the rule of law, and we try to reflect that in our work. And as I said, we did not just get up one day and say that we're going to stop publishing the databases. That database has over, I think, $250,000 contract award entries, running into over $1 trillion. Someone pointed out on social media recently that the GoJEP site replaces that. It can't. Our database, they've been tracking contracts awarded from May 1, 2006. And that's almost 20 years. And it's freely searchable by any member of Parliament, any member of the public. No member of the public can just go on the GoJEP site and search for contracts. In any event, they won't find it going back to 2006. Only the Interim Commission, having assumed the responsibilities and all the data resources coming from the Office of the Contractor General, has that information in its repository. And it's very important. It's a great tool for transparency because it tells the taxpayer how their money is being spent. If public body A, you want to track all the contracts it has awarded since 2006 up to now to a particular contractor, you can get it like that, and it tells you everything. You can put in all sorts of permutations in your searches.
So just a follow-up on this, as have all your questions been? All right, let's have that.
To the third question, Chairman, through you, Member Robinson has asked for the percentage of cases that have been referred to external entities, as well as what is the rationale for referring matters or not. I just did a quick calculation over the 5 years period. It's just over 3% of cases that have been referred to external entities. When we are looking at cases generally, and whether or not they should be referred, we have to be mindful of the remit of the Commission. Although there are other entities with similar or complementary powers, we have to be careful not to divest the functions that we are to perform, particularly when you look at the independence of the Commission in the treatment.
Need expert plumbing services? Mr. Rooter Plumbing is here for all your plumbing needs and repairs, like clogged drains, sewer system backups, leaky pipes, and water heaters. Your service professional arrives promptly, identifies and provides upfront, flexible pricing options so you know what to expect. Backed by our done right promise, if a job's not done right, we'll make it right. With 24-hour phone support, we're always available to schedule your repair or replacement. Call Mr. Rooter Plumbing today.
This is so damn small. No, I'm just kidding. This is the Insta360 Go 3S. It's so small and unobtrusive, which is actually handy for any kind of like POV stuff. This is so much smaller.
In at least one or two of those investigations. So the rationale around it is really the subject matter. What is the subject matter that is being investigated? Can we pass this on to another entity to investigate it, to be investigated, particularly if they do not have the remit to investigate that matter? And if you're looking, for example, at statutory declaration related matters, who would we refer it to be investigated? For example, if you're looking at just purely the statutory declaration, then of course you'll have to refer to the functions of the commission to investigate these matters and whether that can be carried out by another entity. But as I've said, we've cooperated with other entities. We have from time to time meetings. We try to do them on a quarterly basis. Particularly in recent times, we're trying to get back to our quarterly meetings with our competent authorities and other partners to ensure that we keep good relations so that we can share information where it is possible for those that are listed under Section 7 and for those that have not been listed, to ensure that we work out a way where we can get information from those entities.
Okay, well,
Chairman.
we are going to continue the discussion. Bear in mind, of course, that we have to 12 o'clock today. Well, I may then have to excuse myself, perhaps, and ask you to chair for any further leading up to 1 o'clock. But I do have an obligation at midday. But suffice it to say that the comment made and the explanation given by the director, Christie, is apropos in relation to the work of another committee. And I sit in both capacity, as I wear both hats, and I'm fully seized by that. And we are particularly seized by the seeming levels of contradiction within the act itself, two of which we raised just in this committee meeting here today. But there are several others, and the breadth and width of it, and what it does, even in instances of, threatening to breach natural justice and various areas of, individual liberty and so on. So we need to take that deeper look, and I'm very happy that the discussions here have brought out even further the need for us to move faster, in fact, in dealing with these legislative amendments that the JSC is responsible for. And I can give you my assurance that we will be acting very expeditiously on these matters, starting the latter part of this month into the end of the year.
Chairman, I had a follow-up question to what was just said by Mr. Christie. He refers to being the relevant section, and in my understanding, relating to the constraints placed on members and officers working in the Integrity Commission. But as it relates to members of Parliament, for instance, because we're speaking a lot about the parliamentarians, a member of Parliament would be in breach of Section 56 or Section 53(3) if it is that they were under investigation and published that information. All right? Because we have clarified that members of Parliament under investigation would be in breach of the confidentiality or 56, in your opinion, Mr. Christie?
I'm sorry, just to indicate members that I do have an appointment with the non-resident ambassador for Rwanda to Jamaica. And he's passing through, and I did make it for 12 o'clock because we had hope for a 2-hour meeting. Yes, and so I will excuse myself to meet with him, and Member Chuck will assume the chair until my return. Proceed, Member.
I had asked a question, Chairman. Very important question for me to understand.
Yes, Chair. Member Charles, I think it's a fair question in the circumstances, given the language of both provisions, as to does it prohibit just members of the commission, employees of the commission, or does it extend to other persons? The commission actually issued a statement with respect to section 53.3 the other day, when there were some reports from at least one media house about our investigation reports, which had not yet been tabled in Parliament. Not reports, one report. And the point that the commission made was this. It says, and this is what it highlighted. I'll read the entire section and tell you what were highlighted. Onto the table in the Parliament of a report on a section 36, all matters on investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of investigation in this act. So it's or any other person.
Including members of Parliament.
Well, what was Parliament's intention? Parliament wrote the law, or any other person.
So what
Again,
I was asking, Mr. Christie, not to
yes.
stop you, but I'm under constraint of time, and that's my follow-up to Member Robinson's question, but I haven't posed my question yet. So we are clear now. Members of Parliament under investigation would be in breach of the confidentiality if they were to expose
That's not
it.
my response.
Okay, guide me.
not
What
my
is your
response.
response? What is your response? Guide
I
me.
told you my response. I simply said that we issued a statement which alludes to this phrase or any other person. You can interpret how
Okay,
you want.
so let me make it
Yeah.
clear. Members of the IC and any other person
That's what the law says.
ought not to speak of these matters until they are tabled.
That's what the
That's
law
what
says.
thank you for that
That's
clarity.
what
Now
the law
on to
says.
my question.
No, I don't think you're finished. You also asked the same question with respect to section 56.
No, well, what I asked originally was whether you would find the constraint on a member of Parliament within section 56 or within section 53.3. But you went on to provide commentary on a statement made by the IC around it, which was useful. But you haven't told me if it is that a member of Parliament specifically would be constrained while under investigation in 56 or 53.3.
Member Charles, you've asked a question and I provided my answer. All I'm telling you is that the law was written by Parliament, and I think Parliament is the appropriate
Your answer is
entity.
sufficient. No problem.
What's
Answer
your-
is sufficient. But let me go on to my, because the clock, we're watching it. Chairman, I think that the matters before us today and the discussion and the report and issues relating to the Integrity Commission ought to receive more than the time that we have allocated to it. It is of great importance. But I want to say this. Thank you for the clarity in relation to any other person. That includes members of Parliament. But let me go to what I see as an insightful and thought-provoking opening from our chairman of the Integrity Commission this morning, who it is an honor for me to be in the position to listen carefully to what the Honorable Justice Panton said and he has made a statement to the nation which is very clear and which causes me to have deep concern. It is evident the frustration expressed by the chair in relation to perhaps the perceptions around the Integrity Commission. And it is concerning to me of the impact that that might have in terms of the operations. Nevertheless, I want to join with Chairman Panton in his, one, highlighting that our Prime Minister has given full support to the Integrity Commission and acknowledging even the commentary of the Prime Minister in terms of how he views the Commission and how he views the importance of its objective. It's important to put that on note so that the public can know that that is the feeling of the Integrity Commission in relation to the Prime Minister's stance. Secondly, I want to acknowledge the strong rebuke of any statements that contribute negatively to how our society sees the Integrity Commission or sees even our engagement. And matter of fact, the specific words were such statements that fuel a sort of mood among psychopaths and that focus on the society that we live in, and that we need to understand persons, we have to be careful of what we say. And in that context, even though this was not the intention when I stepped into the Parliament this morning, but because of the statements, I'm compelled to ask of the Commission's perspective in that context on statements that have been made by the Executive Director in September 2023, when following the unfortunate incident on Director Evans, we heard a response saying, you should ask the government that, ask them what it means. I note the response in writing, the explanation, but I would like to know objectively, and this is not an attack. In this space, we should be able to have honest, open conversation, and the country wants to know this. So let us put it to rest today. What, Chairman Panton, is your perspective on those comments from our Executive Director following such a significant and unfortunate incident? Do you consider those statements to be statements that you would categorize as such that fuel a sort of mood among sycophants and statements within the category that we should be careful of because of how the society would view them? Chairman, I'm very interested in knowing that. And in that vein, I have other issues, but I will ask the Chairman that first and then move to the other matter.
Yes, Chairman. Not really in an argumentative mood today. I'm in a very docile mood today. I'm surprised that that statement by the Executive Director has been raised again. The fact of the matter is that those of us who are on the Commission were in a position then, at the time of the incident, to understand why the Executive Director reacted as he did. Now, there were some very serious security concerns. I don't want to go in depth, but I have to say, because that Commissioner Anderson, Commissioner of Police Anderson, gave certain instructions to one of his senior members, and those instructions were not carried out. Had those instructions been carried out, the incident may well not have happened in respect of Director Evans. And in fact, Mr. Chairman, as a result of the disregard of the instructions of Commissioner of Police Anderson, I had to write a letter to the Prime Minister of Jamaica, copied to the Minister of National Security, exactly 1 week before this incident. And there's much more I could say, but the reaction by the ED was, to our mind, understandable. I leave it at that. I'm not saying anything more on it, Mr. Chairman.
Yes. So, well, when the chairman speaks, I know for sure it is final. He's not speaking further on it. But, you know, Chairman Panton, as to you in saying, clearly, you know, I have no intention of being antagonistic to you. That would cause me to be scolded in other places. However, I am compelled to ask the question because we sit here not just in our own individual capacity, but we sit here representing the nation, a nation that has asked questions, and it may be best for me to pose them in this way because it gives an opportunity for the Integrity Commission to ventilate an issue, which is critical. The Integrity Commission is one of the most important institutions in our country. And we don't want a situation where you, Chair, or your commissioners feel in any way that the Parliament is attacking. And when I note your opening remarks, I note your reference to our psychologists perhaps assessing us and us needing to examine what we're digesting as it may be impacting us in particular in terms of how we operate. And that's the kind of engagement that I believe the country would want between the IC and the Parliament, nor is it the kind of perception that we want. So it is our responsibility to dispel that and to remedy it if it is that there are things that have been done or are being done to cause you to feel that way. You are an important element in terms of advancing transparency and accountability in our country. Chairman, a big part of that also requires us to look into the Integrity Commission itself. Because as I've said before, advancing integrity must require you to have integrity. And it must require you not just to have integrity, but for the country to have confidence in you being a person of integrity. Conditions are critical. And sometimes the reality and the perception does not meet. But we can't afford for that in these kind of circumstances. For instance, Chair, and I'd love to hear from Chairman Panton. Again, we speak about the society and the need for us to ensure that we are careful in how we operate. And from time to time, we hear comments about this matter that unfortunately occurred with Director Evans. And we even hear about the delay in responding to police officers. I don't know if it is true. I'd like to know as a member, because these are the things that are impacting the perceptions that the public have on the operations of the Integrity Commission. It could be not true, but I'd like to know, is it that there was a delay in signing the witness statements, a delay in responding to the police that has caused these perceptions to fuel? Because we cannot contend with an Integrity Commission that some members or too many members of the society, including members of parliament, do not have confidence in. You often hear, and I've heard before, commentary about Director Evans being a former advisor connected to political persons. Are these matters that the chairman and the commission have taken into consideration in terms of his operation? Are these matters that they have determined whether there is impartiality or conflict? And if so, how have they operated? How have they dealt with those issues? I have no issue with director serving, but I would want to know, as a member of this committee and as a citizen of Jamaica, how have we addressed these issues that so many persons in our society talk about and that have crippled the perceptions around the Integrity Commission? Now, many people don't want to ask these questions because they are uncomfortable and it may cause discomfort. But my intention is not to be combative. I have no issue with Director Evans. I have no issue with Executive Director Christie. But I have a responsibility. And so I lay these things before us, not to be combative, but to be probing on behalf of the nation and to elicit a response that will cause me to be able to say to Jamaica, we can be confident that these matters have been deliberated, discussed, ventilated, and here's how our Integrity Commission is operating. And it's an important part of the discussion even around these reports, because all of it must be linked to the confidence reposed in the Integrity Commission by our people. It is the people that we serve. It is the people who are ultimately in charge. So, Chairman, again, let me just close off my remarks. I have other questions, but I want to close off this first one in just saying to Chairman Panton that I listened extremely carefully to the opening remarks. I listened even to his concern around the dispatch of matters from his office to the parliament, and the fact that some of those matters throughout that journey have been exposed before being tabled. And I wonder, even in this recent one, where I can be guided, where I think a member of parliament was actually able to make comments and address the matter before it was tabled. I share in the chairman's concern, but the question now for us is, what next? What do we do? What are we going to do to address those matters around the perception, statements made by executive director, the perception around the viability of a director in terms of his potential impartiality, and this repeated leaking of matters, whether it is from the IC or when the matter is moving from the IC to the parliament. These are problems that are impacting the credibility and the confidence that Jamaica can have in one of its most important institutions that our Prime Minister, as the chairman has said, has lauded, has supported with increased allocation, and continues
Oh.
to hold in that high regard.
May I answer?
Okay, just before you do, Chairman, I did indicate to you, and yes.
I want
and
to answer
should be
while you are
back.
present. I want to
I'll
answer.
be back
It
in
will be
15
short.
minutes because
It will be short. It is nonsense for this. It is nonsensical for there to be any discussion in respect of Director Evans. Director Evans went through a regular process for recruitment and employment and was appointed by the Governor General. Now, we need to bear in mind that Director Evans has nothing, absolutely nothing to do with reports. Nothing. His job is to go out there and inform people in respect of corruption. He has nothing to do with reports or prosecutions or non-prosecutions. And the fact of the matter is that we need to remember that our second, third, and fourth governors general were active politicians. So bear that in mind when people are talking about somebody having worked with a politician for a period. Our second, third, and fourth governors general were senior active politicians for all their lives. And they served the country well. And this question of partisanship, we need to debunk it. And there is no question about the leak being attached to the commission unless you can prove it. Why wouldn't there be a leak while the thing is pending in the commission? And why is it as soon as it reaches Parliament, there's a leak? Think about that.
So with respect, I think the direction that this is going, yeah, and I believe that an answer is necessary. Yes, I do believe an answer is necessary, and I'll allow the member Charles to complete what he has to say in the presence of member Chuck in the chair, while I discharge this other duty and come right back to the meeting of this commission. So
Thank you, Chair. And let me, I took the opportunity when posing my questions before to reiterate that I have no intention of being antagonistic. And I really want to just reiterate that. Comfortable or cause discomfort is not because I'm trying to cause any argument with the Integrity Commission. It is because these are real live issues, whether we like it or not, that are surrounding us. They are consuming the discussions around the more pertinent things that we need to move towards in terms of transparency, accountability, and strengthening that framework in the country. So I say this with the hope that no one on that side consider the questions in that way. And therefore, we could get some answers as opposed to comments, because answers might actually assist us, I think, in dispelling a lot of the rumors and issues that arise in the public domain. That said, we spoke of the rule of law, which guarantees from interference as well. And when I raised the issue, Chairman Panton, around the director's relation with a political individual, I raise it because of the comments that have been put in the public domain of the possibility of impartiality, and with the intention of not saying he's impartial, but asking the Integrity Commission what steps are taken to address these issues. That's why I raised it. As it relates to the matters before us, I have one other question. I wanted to find out and to interrogate rather how the commission views interim reports. Do we have such a thing? Maybe Director Stevenson is the proper person. I don't know. Chairman, you can decide who. But do we have such a thing as interim reports? And would interim reports ever be placed before this Parliament as tabled?
I'm trying. Huh? Turn the mic off for the moment.
Through you, Chair, presiding, to Member Charles, in the preparation of investigation reports and the conduct of investigations, I am only guided by Section 54. I do not see under this section a provision for interim reports.
So all the reports that have been tabled are final reports.
54, yes.
All right. Member Fort has not. Will you allow her to ask some questions before members Robinson, Poland? I am allowing you to. No, but they had their mics on before you. Well, he said that there's nothing as interim report, so everything is final report. That's the understanding I'm having from him. Is that so, Director?
Once the report is submitted under Section 54, Chairman, I believe it is a final report. Well, as far as I can see under the section, there is no such provision for interim report.
Yeah, so I just thank you, Chairman. You see, we can't afford for there to be any misinterpretation of what is said. So yeah, I think it is critical for us to be clear what the director is saying.
He's clear.
That anything put forward is a final report and there is no room for interim reports.
Member Ford.
Tabled before the Parliament.
Thank you, Chairman. I join in welcoming the Commission and its staff to this sitting of the Oversight Committee. I have about 4 or 5 questions. I think the exchanges are helping us to gain clarity on a number of issues. My first question is directed to the Chairman of the Commission, Justice Panton, whether you are of the view independent exercise of statutory functions means that one is accountable to no one else.
First again.
No, I'm not of that view.
Thank you. The second question is whether you, on behalf of the Commission, ever refused or rejected an invitation to attend upon a meeting of the Integrity Commission Oversight Committee prior to today?
No.
Thank you. In your opening remarks, you chided that the Commission takes orders from No one other than the court. Are you of the understanding, or what is your understanding of the nature of the IC's accountability to Parliament, having regard to sections 4, section 5, subsection 4, and section 6, subsection 3? Section 5(4) is a provision which states that the Commission shall, subject to section 34, subsection 3, and section 36, subsection 4, be ultimately responsible and accountable to Parliament for all matters relating to the functions of the Commission. The two provisos, 34(3), relate to the Director of Corruption Prosecutions not taking directions from anyone, and section 36(4).
Transform your company into a great place to work. Get started at surveymonkey.com/employee-love.
And I heard you say, I heard you say,
Your understanding of the nature of the IC's accountability to Parliament, having regard to sections 5, subsection 4, and section 6, subsection 3 of the Integrity Commission Act.
My understanding is that the Integrity Commission cannot be ordered by anybody other than Parliament. That doesn't mean that it isn't accountable, because everybody is accountable in public life to at least the public.
You said to Parliament, I think you meant the court.
What's that?
You said cannot be ordered.
Cannot be ordered by anybody other than the court.
You said Parliament.
Well, that of course would have been a big slip. Because that would not happen.
My other question at this time?
I thought you said 3.
No, I didn't say 3. Or at least I don't recall saying 3.
You don't recall? Yes, Madam Minister.
Has the Commission examined the practices and procedures of any public body?
Before you, could I just to, a number of students are here and I know they're leaving shortly, but I want to say to the students, if you don't mind, I just want to thank the students of attending Parliament. They're from the St. James Prep, 44 students and 10 teachers. You have been sitting there silently. I hope you enjoyed the session so far and continue to have a very good day. Okay, it's okay. You don't have to clap. You can go now. All right, okay. Continue.
Has the Commission examined the practices and procedures of any public body with a view to making recommendations to the Parliament in relation to the revision of those practices and procedures? To the function of the Commission set out at section 6(1)(d) of the Act.
The Director of Corruption Prevention may be the one to answer that. The one who his name is popping up just because of his previous work history. Director Evans.
Who is that? Go ahead. Sorry. Go ahead.
Good morning. Well, it's now afternoon. Chairman, members. So in terms of the work of the Corruption Prevention Division, actually substantive elements of Section 6 speaks to the work of the division in terms of preventing corruption. we have spent a lot of time over the last 3.5 years since the division was formed on public education. We spent a lot of time on developing a national anti-corruption strategy. And we have also done a lot of work in terms of stakeholder engagement. And in fact, on our website, we actually list on a quarterly basis the interventions that the division would have done over the last 3.5 years in terms of public education, in terms of stakeholder engagement, participation in conferences, workshops, etc., stakeholder engagement, etc. And we have done substantive work in that regard. In respect of section 61D, which speaks to the practices and processes of public bodies, that is an area that the division we have developed a concept as to how we intend to do that. And the idea is that it wouldn't be punitive. So the idea is that and we have developed a risk template, and we intend to go into public bodies and say, we plan to do a survey first as a first step to see what are some of the practices that you currently have in vis-a-vis corporate governance architecture. Do you have, for example, an audit committee, a procurement committee, an IHR committee, for example, amongst other questions? Once they respond to us, we will then, using other indicators, develop a risk profile of the organization, whether low risk, it's a low risk, it's a medium risk, or a high risk. We will then assimilate that data, interrogate that data, and make recommendations to the public body as to areas to improve the architecture. In addition to that, the investigation division does, in fact, in its reports, makes active recommendations vis-a-vis risk assessment of public bodies. So as a division, we haven't formally started the process yet. Again, the division it's a young division, 3.5 years, and we have spent a lot of focus on other areas, but we do intend to advance this particular area in this fiscal year. And I can assure you of that, member.
Thank you. I have another question at this time.
Sure.
In the investigation of complaints and the review of statutory declarations, is the Commission of the view that it has the power to pierce the corporate veil without an order of the court?
In fact, Brent, yes, I'm doing so.
So for members of the public who may be listening and watching, in law, a company is regarded as a separate legal person. And there are specific principles of law in relation to how a company is treated vis-a-vis its shareholders and its directors. And I'm just seeking an understanding of how the Commission carries out its functions. So I will repeat, whether the Commission, in investigating complaints or in its review of statutory declarations, is of the view that it has the power to pierce the corporate veil without an order of the court.
As a collateral question to that, can declarants or should declarants be asked about the assets and liabilities of limited liability companies of which the declarant or the member of parliament or public official is a member? On what basis do you do so, which is ancillary to that question of piercing the corporate veil?
Chairman presiding, through you to Member Malahoo Fort. Before proceeding to answer your question, though, I am constrained in saying that there are certain matters before the court, and a part of the application deals with the issue of the corporate veil, and I would be very responsible to go down that road at this time, except to say that insofar as we have operated, we believe that we are complying with the law as it is.
My question does not relate to any particular case. My question is a general question in respect of the approach taken. So it's not in respect of any particular case. Those who have spoken have been at pain to reference the law, even offering a view that some provisions of the law may be in conflict. But we're talking about principles of law and an understanding and an approach that is taken.
I still, Member Ford, have to be cautious in how I approach that question, because anything that is
It's a simple
decided,
yes or no, you know.
I cannot answer in that way, except to say that insofar as we have conducted investigations based on the circumstances of each case, we believe that we have complied with the law. But in terms of that particular question, I think it's a matter that has to now be decided by the duly constituted tribunal, and I would not attempt in any way to assist the tribunal or to influence it in any way by answering, even generally, because, of course, the law, as you know, would be of general application.
You are not an attorney at law by profession, Mr. Stevens, are you? You are? Oh, I'm so sorry. Yes.
Well, I hope it is not because I have not acquitted myself well
No,
by
not at all.
answering that question.
But,
Not at all. Just one other question.
no,
at
but
this
I mean,
juncture.
the ancillary question, Director Stevens, is it relevant to be asked in deference about the assets and liabilities of limited liability companies? Not the deference interest, but the assets and liabilities of limited liability companies.
Mr. Chairman, the ancillary question, as you term it, it still goes to the heart of the particular question that Member Ford asked. And so if I answer that, I would really be answering the question that Member Malahoo Ford asked. And in respect to the court, I cannot answer that question at this time, but I am sure that in due course, the court will return its ruling in the matter and we see around it.
I have another question. When the Commission requests information of financial institutions about the accounts of declarants, as you have done in review of statutory declarations, do you inform the declarants that you are seeking information from the financial institution in respect of their accounts, having regard to the laws around banking secrecy?
Insofar as my functions are concerned, I do not inform the declarant that I am requesting information about their accounts, and I believe that I am covered by Section 48 of the Integrity Commission Act, which speaks to the secrecy provisions and other laws of a similar nature, for example, the Banking Act. So I go under that provision to ask questions. Now, as a matter of investigative strategy, in most instances, it would be foolhardy to inform a declarant. Section 48, I believe it's about 48.4. I could check. It should be about 48.4, but you can always check, and I will come back to it. But it perhaps would be foolhardy. Okay. All right. Thank you. You want to go first then?
Sorry?
Chairman,
Yeah, okay, Member Robinson.
I'm referencing the annual report of 23-24 and the chairman's opening remarks, the second page, paragraph 8. And I would like clarity clarity on this particular matter.
The 23 report.
23-24 report, the chairman's
What
page 2 of the chairman's opening remarks, the end of page 2. If for the 272 is page 8 of the 272 pages, and it's at the bottom. And I'm going to quote the last sentence written by the chairman, and from my interpretation, there appears to be a bit of a contradiction. And I quote, "Of course, there is nothing to prevent declarants or persons under investigation from speaking on the situation as it relates to them." So I am seeking clarity. If a declarant is under investigation before the report has been tabled in the Parliament, is it against the law for the declarant to acknowledge that he or she is the subject of an investigation?
In my opinion, a declarant can always speak about his or her situation at any time. That is my view of the law.
But it sounds inconsistent with
Well,
what Mr. Christie said.
the section says nobody is to speak about the thing. But I can't see why I am involved in a situation, I cannot speak about it. That is my interpretation of the law. It doesn't follow. Although I think I'm right, it doesn't follow that I'm right.
I'm going to ask the chairman, is your interpretation of the law consistent with the Integrity Commission's interpretation of the law on this particular matter?
What's the question?
If the chairman's interpretation of the law, as written here on page 2 of his opening remarks, if it is consistent with the Integrity Commission's interpretation of the law on this particular matter. It's a very important matter because there have been public comments made that no individual can speak on a matter until it's tabled, even if you are the subject of violation. But the chairman...
No, I don't share that view.
Right, but is that
I
the view
share
of
the
the
view that the commission and other people should not be speaking about matters as forbidden by the legislation. However, in my view, and as I say, it's my view, that a declarant can speak about himself. I don't see anything to prevent that.
All right.
That is my view.
All right. Thank you, Chairman.
It's following this question, not a separate question. So
do you mind?
It would
Go
be
ahead,
logical.
Member Chance.
Just, since I am the one who had raised it earlier, it is perhaps important for me to gain clarity because I am now not clear. Section 53(3), and let me read it. Until the tabling in Parliament of a report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential. And no report or public statement shall be made by the Commission or any other person in relation to the conduct of this investigation. Now, I read the chairman's remarks, and I too noted the sentence that said, of course, there's nothing to prevent declarants or persons under investigation from speaking on the situation as it relates to them. You can't tie somebody out. They can say what they want to say. But the real question is not whether they can say it. You can't stop me from saying what I'm saying right now. But if I say it, am I in breach of the confidentiality and the constraint that is affected by this section? That is what Jamaica needs to understand, not whether somebody can talk, mouth make for talk. But if you talk, are you contravening this section? That is what the country needs to understand from the Integrity Commission.
Chairman, I'd just like to just respond to what was just said. This law was not written by the Integrity Commission. It was written by the Parliament of Jamaica. And if there are flaws in the law, different interpretations, I think that's a matter for the Parliament. It cannot, that hat can't be placed on the Integrity Commission's head. It can't. We have already addressed the issue of conflicting interpretations. It is the responsibility of the country's lawmakers to make clear laws. And if we get into a situation, a pit, where we're, jumping over ourselves as to what this means and what that means, that's a matter for the Parliament to deal with. It can't be our responsibility.
No, 1 second.
It is a conversation that,
No, 1
Chairman,
second.
hold on. No, it cannot be that I ask a question and then we're going to move on. I would like an opportunity for the floor for me to respond. Now, Mr. Chairman, this is the second time that the executive director has responded to my comment. He has made it clear now that the hat shouldn't be on his head in interpreting the law. Now, if the executive director of the Integrity Commission ought not to be called upon to interpret the law, which is going to direct his function, who should? It is not only inappropriate, but I believe that response speaks to the stance of the executive director. And if I ask a question, you can respond properly in giving me your opinion. You see how the chairman responded? That's what I'm talking about. The chairman gave us his opinion and said, I may not be right. The chairman wouldn't look on me and tell us that is for you to deal with. I think that response is not in keeping with the tenor of this Oversight Committee and the conversation we're having now. I'm asking again, and hopefully you will be minded to actually give me some insight into how you think, because how you think and what operates in your mind as the executive director is critical to my understanding of the operation of the Integrity Commission and the confidence I repose in it. So if you're unable to answer the question, then you tell me you're unable to answer it because you don't know what it means. But I don't think so. You are someone who has taught law. You are a respected attorney at law. You have served more than once in this position. Your opinion is critical. It is significant. So let me ask again.
Member, just before, there's a member who seeks an intervention for a point of information. And
To seek intervention in my questioning?
Yes, that's what he says.
Chairman, I just want to note that I was a member of this parliament when this law was passed. And I clearly recall what the intention was. It is to guard against people who are being investigated, being prejudiced. That person can waive whatever protection that he or she might have under the law. It is to ensure that investigations are done in secret, so that the person who is being investigated can have that secrecy preserved. But that person can waive that secrecy anytime by saying, I am being investigated and here are the facts. And I don't see anything wrong with that in terms of the general
Chairman,
provision of confidentiality.
can I just say that the comment from Member Paulwell is irrelevant as a point of order. It has no bearing on the question that I'm posing. He will have an opportunity to speak. Can I finish?
I accept what you say in your...
Listen.
In all fairness, I accept what you've said, but his right to intervene is to be respected.
I respect
So,
it, but
I
I'm
take your
commenting
point
on his
well in
right.
terms of your own
And
interpretation.
yes, I have
of
a
his
right. I have a
intervention.
right to
Not a
respond.
problem with that, of course.
And in the middle of my
So can you
questioning,
please finish? Yes,
you ought
please.
not to obstruct it. We're all members here. And I get the impression.
We've got passion, we've got determination. Like, and if we set our sights on something, you better believe it's happening.
No, but why I'm saying this? You have Jamaicans right now listening to us who are confused. So when I ask a question, it is not to attack anybody. I'm not sent here to be friendly. I'm sent here to be effective. And the question, and this is it. Even me asking this, remember Paul is saying you're being defensive or offensive. I'm not being offensive. What I'm being is probing. And maybe because of my legal training, it is not meant in any personal way. I am probing a matter. And I draw the comparison in how our chairman responded, expressing his own perspective and respectfully saying that he could be wrong. And I can respect that kind of response. But I don't accept that as a member of this committee, I can ask a question and it be said, you who wear the hat, not me. That couldn't be acceptable, Chairman. But let me ask again, for clarity. I raised an issue before around section 53 and 56 asking for clarity whether members of parliament who are under investigation are within the constraint of the Integrity Commission Act in speaking about such investigation before those matters have been tabled in Parliament. The response from the Executive Director to me was to read out a comment or a statement rather from the Integrity Commission that says, in my words, all officers or any other fall within the constraint of the law, and in my terms ought not to be talking about the matter, whether you are in the IC or any other person. I even went on to ask specifically, members of parliament, the response are members of parliament persons. Yes. So that was very clear to me. Now, further to that, we have highlighted a statement, a sentence in the chairman's report that speaks to, of course, there's nothing to prevent declarants or persons under investigation from speaking. My interpretation of that is that you can't time them out. I can say what I want to say, just as I'm saying it right now. But that is not what I think is a relevant question for the nation that is watching us. The relevant question must be, not can somebody talk, but if they speak, are they in contravention of this legislation? Now, for me to pose that question, it's important to answer it. So let me do it again and ask whoever wants to answer. Not can somebody talk, but if they do, are they in contravention of the Integrity Commission Act in its current state?
Chairman, through you, sir. I think before you left, I think what this further discourse has demonstrated, and this has been my posture.
No, it's fine, it's fine. Turn off yours, Minister.
Yeah, thanks. I think this interchange and engagement, what is useful about it is that we're all talking about a piece of legislation which, interestingly, is on a review. And if we read the law, what the law actually anticipates is that after 5 years, observing how the law operates in relation to the commission, is there anything which needs changing? Now, it should not come as a surprise to anyone that there are going to be conflicting interpretations insofar as some provisions of the legislation are concerned. And to me, I don't see why that should cause any level of consternation. I think where we are right now is that we have identified a number of provisions which are capable of more than one meaning. They are equivocal in meaning. And you want to get to a point where you are clear, you're unequivocal in meaning. And I don't think we should be seeking to pin anyone on a particular interpretation A or interpretation B. When we look at the rules of interpretation, legislative interpretation, one rule that you look for, well, there's a literal rule, and I think that's what we're talking about. It says any other person. And the member is right, we are all persons. But there's also another rule. What was the mischief that the provision was intended to cure or to deal with? Was the mischief that was intended to deal with is members of the commission speaking about the matter while it's on investigation? Or as the chairman says, was it intended also to extend as far as to the person who is the subject of the matter? Is he too prohibited from speaking? It stands to reason that the chairman is correct in his assessment in terms of what makes sense. What was the purpose of the provision? The member across the floor, he is hanging his hat on any other person. And that's what I read out. And I read it out in the sense that this is what the law states. Now, what do you, the lawmaker, mean by that? And yes, sir, there are members of the public who are listening, and they are confused. And I think right here, it is for us to get rid of that confusion. So I'll just say this, and I've said it before, and I'll say no more. We have identified another provision which is not unequivocal in meaning. And Chair, with respect, this is another matter that I think should go to the Joint Select Committee of Parliament, if you should so determine. And again, I repeat, it's our lawmakers who make the law. They're not infallible. And this is why we have processes like this, review processes. We're not infallible either. And as I say, this process serves good reason, a good public purpose, to identify errors. It may not have been Parliament's intent to say it this way. Madam Malhu Ford pointed out that, despite Section 6.3a of the Act, which says that the Commission shall not be directed by any person or authority. Parliament is an authority. This committee is an authority. And the words are very explicit. They are unequivocally clear. But yet in another provision of the Act, it says that you're accountable. And there's no one on this side who would say that we're not accountable. I've said it several times in this chamber, that we hold ourselves accountable. And we come here to answer your questions and to work with the committee as best as we can. So, Chair, I'll rest it, and I hope the member understands my position. I'm not here to answer questions in a way that satisfies anyone. That's not me. I will give you my answer to a question as I see it. We have identified another provision in the Interim Commission Act which requires address, and I leave it at that.
Chairman?
Except I just wish to point out that the explanation that you give raises a lot of questions about just how we have operated and functioned, referencing the law and the issue of the interpretation that we may have on the one hand, and the interpretation that the other, particular declarants might have on the other hand. What concerns me at this moment is the actual point you made, E.D. Christie, that the law has to be amended and dealt with dispatch. And I made the comment earlier as chairman of another responsible body that has that overall responsibility, that it will be done, and it will be done with dispatch. Because much of the concerns that are being raised here, the confusion that the member Charles is references, emanates from, again, the imprecise nature of the legal provisions. And the second element that I believe needs to be looked at is the absence of empirical data points for determination of decisions. So that there is probably too much that is left to the interpretation of functionaries in arriving at decisions. So one of the things that we have to look at are there possible parameters to be established, action points to be determined. In other words, a more empirical basis on determining what is required for certification, for example. And so that if we have a list of 1 item, 2 items, 3 items, 4 items, and all those items are met, then certification is automatic. And it removes the individual situation where a director of any area has the discretion to determine. And it removes the reference to phrases like, in his opinion, or if he's satisfied, that there is a system that everyone understands, both the declarant and the commission, as to what constitutes the satisfaction level. And once that threshold is reached, there's no question about certification. So these are points that we have to look at down the road, and definitely is part of the consideration that the JSC is seized with as we move forward.
Chairman, no, but there's some things have been said that I would like to quickly respond.
But in all fairness, you know, we cannot continue. Yes, right. So please, it's now, as we say, 12:51. Yes. And I want to make the point that I'm fully seized of how important this particular meeting is, and particularly that this is a historic meeting. It's the first time we're having the full commission before us. And it's only that we're going to have more of this. And I will sincerely hope that, you know, we can, after this meeting, structure another to continue perhaps elements of this discussion that are left undealt with. So I will continue, but bear in mind, Parliament must be ready for preparation at 1 o'clock. There's absolutely no getting away from it, because we begin at 2 in the next session. So Member Charles, kindly wrap up, and then we have quickly from Member Malahoo Ford, and then.
It is telling what has been said around this provision. In my reading, I recall about strategic ambiguity, where persons can see something that is clear as unclear in order to foster debate, or what some call selective interpretation, where a clear statement or law can be seen as unclear if it doesn't align with the objective you seek. Now, I want to draw a distinction between one's aspiration and the reality. The law as it is now is the reality. What you want the law to be is an aspiration. And what I'm asking about is not your desire or aspiration. It is the reality of what is as it is right now. Now, the country, as said, is listening. And we have spoken about a number of things. The reference, Chairman, to Section 53 as a law that is unclear must be probed further. I would like to understand what word, what part What element of that is unclear? And let me read it so that the country can hear it. Section 53.3. Until the tabling in Parliament of a report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no NO report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation under this Act. I would like to understand two things. What part of that you don't understand? What's unclear? And secondly, when I first raised it, the response from the executive director was to reiterate, it says any other person. So this member, who he says is hanging his hat on the words any other person, I hang my hat there, sir, because you gave me those words to hang my hat on. You are the one that pulled it out of the section when I spoke of it. You are the one that highlighted it. You are the one that asked me to use that as a form of interpretation. How come you now changing what you're saying? I don't understand. And you see, Chairman, it may come off as combative, but that's not my intention. I see clarity. We cannot have a situation where a member of this committee asks a question and it's basically thrown back at me. And the comments is, you are the parliamentarian, you are the legislator. If you make a mistake in the law, for your problem. Well, I'm going to tell you what the big problem is. The big problem is if you have an executive director who is interpreting his aspirations and not understanding his reality. And that is what I am probing. Because if that is the case, we have a serious problem.
I will yield to the judge. I will yield to the judge.
I think we have been talking about this issue for a long time, and I think it's a very simple matter. And it was addressed by Member Paulwell. When we look at interpretation of statutes, we'll have to make sense of them. Is it being suggested that if I am a declarant and I have been cleared, I cannot say that I have been cleared? As Member Paulwell said, the whole purpose, and when we look at this section, it is my view that the purpose of this section is to protect the person who is being investigated. Nobody can say anything about him. But I cannot see if this person has been cleared or the investigation is discontinued. That he can't say it is discontinued and I have my declaration certified. It would be nonsensical in my view to have such a conclusion.
No, we're not
Chairman,
going to.
Chairman,
We're not going to.
may I,
So, yes,
may I,
please.
Chairman? This session is intended to bring some clarity on a number of matters. And certainly from the Oversight Committee's perspective, mine as a member, we're seeking to get a better understanding of the approach taken by the Commission in discharging its functions and exercising its powers under the Act. I believe that Mr. Christie is right. The law is passed by Parliament. And if there are errors to be corrected, the correction is to be done by the Parliament. But Member Charles is also right, because he is seeking an understanding of how the Executive Director interprets provisions of the law. Unless and until a provision is changed, It is a provision that has to be implemented and enforced. And you can only get an understanding of the approach if you understand how the provision is interpreted. Unfortunately for us who are lawyers, we know that there are rules of statutory interpretation, starting with the very basic rule. You take the words in their ordinary grammatical context. I mean, the literal meaning of the word, ordinary grammatical meaning in context. A statute has to be read as a whole to prevent any inconsistency. So I don't think that it is unhelpful for the executive director to remind that there are problems in the legislation. Parliament has the power to correct. And fortunately, the legislation is under review. I don't think it is unreasonable for the member to ask, how do you interpret a provision, even in the presence of inconsistencies, to enable me to understand the approach that is taken? And it is only by asking and answering that we gain clarity in the matter. I do not believe that all of the issues that require answers will be answered in this session. I do not believe that all the matters that require clarification or that need to be addressed to ensure that we have an effective system in place will be addressed in this session. So I too look forward to other sessions. In the meantime, I really just want to ask the Commission to consider a matter that has to do with the burden of compliance. A number of declarants, many of which are not in the parliamentarian class, have spoken to me because of my role as the Minister of Legal Affairs in respect of the burden of compliance with the legislation. And it is my understanding that where there are omissions in a statutory declaration, the Commission asks the declarant to resubmit the entire statutory declaration. I don't know if that is correct. Is that so? That the entire declaration for the period has to be resubmitted? Just say yes or no. I'm happy to hear that.
No, do it on the record.
No.
I'm so happy to hear that, because I would then suggest that an omission can really be corrected by way of an addendum to the declaration for the particular year to reduce the burden of compliance and to ensure that compliance is done in a timely way. So I'm very happy to hear. So those who have omissions in their statutory declaration can, on communication with the Commission, make the corrections by way of addendum as appropriate. As appropriate.
But could you repeat, please? Thank you.
I understand that each declarant's matter will be subject to the particular assessment that is done between the Commission or the respective director or wherever it is being assessed. But as a general rule, it is my understanding that omissions can be corrected by way of addendum. Additional information without the need to resubmit the entire statutory declaration for the period under consideration.
All right, thank you very much. As it concerns the issue of omissions, it's not as straightforward as you have put it, committee, because it all depends on frequency. You have persons who each year they have omissions. We're not going to ask them to resubmit. We may put it to the Commission.
No,
I'm not. Those matters be escalated.
I'm not talking about complex matters. I'm really talking about
a straightforward,
straightforward omissions that the omissions may run more than 1 year, of course, but they are straightforward matters.
Yes, indeed.
Very well.
Yes, they can. I will have to double check though on one particular matter, because remember, you're required to sign in front of a JP to attest to the signature.
I mean, the additional matter would have to be certified.
Correct, correct. So it would have to be certified also using the similar language. So yes, it's something that can be done once we can get the JP signing off. But most persons will opt, based on our examination so far, to submit the entire thing, because I can tell you, based on our examination, there are a lot of omissions right across the declaration.
Right.
So it makes sense most times for them to get it completed and resubmit. But for
Understood.
simple one-pager, it has happened in the past and it's allowed.
Chairman, my last comment. When we communicate,
Each member will be allowed one last comment.
Oh,
Because we will have other sessions. We have to have other sessions.
I will,
There are a number
I
of
will
matters
yield to
here
those who have
that
not
I
asked
have,
their
which we
question.
have not been able to raise as yet, which relates to the actual performance and some of the issues, particularly your EDS program for the declaration. That's very important, the electronic declaration arrangement, and a number of other such matters operationally that we want to raise with you and have clarification on. So we will have to ask you to come back. But we are constrained. The clerk of the house is here on that side looking at.
okay, Chairman.
So
Okay, Chairman, well, perhaps I can go ahead. And I suspect, and I don't think we should be encouraging commissioners to come to Parliament to be questioned by us. I fundamentally disagree with that, but let me go into the question that I want to put. And it's going back to what I believe our role is. I want to go back to public education because prevention is better than cure. And having been subjected to some of the lectures by the commission, I want to recommend, Chairman, from this committee that all civil servants who are within the framework of the law, that they be mandated. Now, that is what we can mandate. Some education by the commission. And in that regard, to recommend that the commission revisit its staffing for public education and that we will approve any such budget that comes to us for the expansion of that staffing. Secondly, again, I believe a role that can be played is to guide us in some of the things that we have been criticized over. So I would like to know, as a member of parliament, what are some of those conflict of interest that we need to be wary of? What are some of those functions that you perform in your private avocation that might run afoul of the law? And certainly, when we become government, what can a cabinet minister do and otherwise? I think those are important functions that, of course, prime ministers are being questioned about what they do now, much less me. And thirdly, I would like to know, Chairman, in your very first paragraph, you raised an ethics issue. I'd just like to know if you have received a response from the speakers yet.
I could have mentioned it at the beginning, but I didn't really want to. No, the speaker has not even acknowledged receipt of the letter. And regrettably, there are some patterns of behavior that trickle down, it seems, because I've written twice to the financial secretary, who has not even acknowledged the letter either on either occasion. So I don't know if it is a pattern not to respond to me or the commission.
I rather think not, Chairman. Okay. I happen to know of one of the circumstances, and I think that you will be responded to, I'm sure, in due course. A little patience sometimes works, Chairman.
Oh, I have learned in life to be patient. Once you went to Rossi's, you would learn patience.
Okay. To the point, however, I am of Minister Member Paulwell's comment with regards to the presence of the commissioners. I think that it is important requirement that we meet and exchange ideas from time to time. And it is important for the commissioners to be seized with what are the concerns of the Oversight Committee from time to time. And I think that we were able to have a very useful and valuable discussion at another place.
There's one
that
question.
emphasized
There's
the
one thing.
importance of our meeting from time to
Chairman,
time.
there's just one thing that I should tell you that as chairman of the commission, I have been wondering whether the reports are actually being read.
No, the reports are being read. Well, we're doing better than that.
A healthy business starts with happy employees. As an HR leader, you need to know how they really feel. How do you do that? You ask them for their feedback. Dare to ask the questions that matter at surveymonkey.com/employee-love.
223, and all that information is fresh. The whole idea is that we're trying to build more capacity for the committee to be able to respond better to the reports that you're sending and to be able to work with you to enable the compliance that we're about. And this is why the element of Member Paulwell's comments that I find favor with is the whole business of escalating the support for declarants to be able to comply timely and appropriately. And I think that one of the big responsibilities to enable compliance is for us to establish a department, perhaps even, that offers support. Because several of the declarants are ignorant of most of the accounting principles and so on, which guide how this very voluminous document called the declaration form are structured. And several sometimes are in trepidation trying to fill it out, especially because of the legal implication of each page having to be signed by you and notarized. So it's a legal document. And so and a number of persons have come into public life, you know, with limited knowledge of these things. And guided by and it does, because there's no glory in prosecution. There's glory in compliance.
We would be
And
happy,
being
you know,
able to
if
report that we have 100% compliance by.
we would be happy if the law made the declaration form just two pages.
My final comment, Chairman. Even as I look forward to further engagements, I'm coming away from this meeting reinforcing the view that I had when this act was presented to the Parliament. Those who would recall, I expressed the view that the law needed to be completely rewritten, that the model needed to be rethought, and I am of that solid view that the law needs to be completely rewritten and that the model needs to be rethought. And that is what I'm going to take away from this meeting with a recommendation for implementation. So between yourself and the member to my right, who have to my left with responsibility, please take note. The work needs to be accelerated.
20 years' time.
We take note of that final comment. Member Charles, I see.
20 years time.
Thank you, Chair. Perhaps in my understanding of what I take away, it doesn't accord with what I take away is that we need to be clear on the difference between recommendations and reality. That's my taking. I have read the recommendations that have been proposed by the IC, some of which I think are prudent, some of which I don't agree with. But we will have an opportunity, I hope, to go through that. But the nation needs to understand that we are now governed by the law as it is. And that should be the subject of our operation. You know, in the opening remarks, and I go back to Chairman Panton, and I only do so because of my respect for him. He is someone who, as a law student, you have no choice but to look up to. As a young attorney, we're not young anymore in it, 20 years now. he is someone that you see as judicious, a man of God. And he made reference to some of us perhaps visiting him on Sunday.
But he goes to church.
I go to church on Saturday, but I have no hesitation in still joining the chair. But you know, as we close, it is our Almighty that said to us and reminded us that simply calling him Lord and acknowledging him won't be enough to secure a place in heaven. What truly matters is doing the will of God and living that life aligned to his teaching and values. Not everything that is said and done will accord because it is said and done. Chairman, these are serious matters. I want to thank the commissioners, Justice Hibbert, great respect, and others for coming before us, Mr. Crawford, Mr. Powell, and the members. And I want to assure them and hope that they leave understanding that my probing is not meant in any disrespect. It is meant for me to carry out my function, which...
Hey, it's my birthday.
Hope that we can continue to have probing discussions so that the country that we serve will benefit. The last thing I'll say, Chairman, is that it is troubling to me, the response to the questions around particular clauses in this legislation. It is troubling because basic interpretation follows rules and principles of law. We have an Interpretation Act, and we have different ways to interpret literally, etc., going down, as has been said as also by Member Malahoo Ford. Either the inability or the decision not to see that clearly causes me a lot of concern. And I do think that we will have to have some discussions further around what is now the current reality and how we're treating with this reality before we even speak about what our recommendations and aspirations should be. Thank you, Chairman.
Thank you, Member. We have two final brief comments, and then we'll just ask for the Chairman to do his summation on this side, and then we break. Member Robinson and Member Chuck.
Thank you, Chairman. My final question is probably more directed to the Chairman. There is a recommendation specific to the Ministry of Agriculture and Fisheries. I don't know if it is still named so, on a particular investigative report. And I'm just going to read what the recommendation says. The Ministry of Agriculture and Fisheries to discontinue with immediate effect the current discriminatory process used to applicants on the basis of prior importation history. The ministry to develop a formal policy that will ensure transparency and accountability in the receipt and processing of applications, as well as the merit and integrity in the issuance of permits and licenses for the importation of all animal products. The Ministry of Agriculture and Fisheries, and by extension the Government of Jamaica, to develop the necessary administrative structures that will facilitate an equitable process for all applicants who apply for permits for the importation of chicken products. This was from the summary presented to us, and I would just ask the Chairman if you can follow up to find out whether these recommendations have been implemented by the ministry. And by Chairman, as the Chairman of this committee, I believe you would be the appropriately placed to do so.
Committee Chairman.
You. Wait.
No, you are giving member Chuck an opportunity
To
say
speak,
half a second
yes,
before
and then I'll respond.
No, a few things. First of all, I want to thank the commissioners and his team for being here, and I hope that in another 2 or 3 weeks' time they can return, because I have had the opportunity to explore a number of points which I certainly would like to raise. Certainly, I want to know, when hopefully you all return, what is the basis or the relevance of asking members of parliament who were elected in 2020 about matters 20, 30 years before, decades before, including, for instance, they purchased car in the 90s or a couple of decades before. Where did they get the money to purchase the vehicle? What is the source of the fund? And there are several similar matters like that, and they were elected in 2020. Is there no statute of limitation as to where they stop? And then to ask member for their employment history from their first employment to now. If that is asked of me, I would be going back 60 years, 60 odd years, when I work in the, picking up trolleys in a supermarket and getting so much profit. These are questions asking members for their employment history, which is 60 odd years in my case. Not that ask me, but similar persons along that line. And finally, Chairman, the chairman of the Integrity Commission speak about no leakage from the Integrity Commission. But a member and this Oversight Committee, not you, was on the platform in August of this year, speaking about reports that will come to Parliament that will be so dramatic that there could be an election this year. Now, how do we know Parliament? How do we know that? But it would be so dramatic. And then, Chairman, the report, as normal, would come a day before Parliament start, or the weekend before. Everyone knew Parliament was going to start on the 17th of September, but it came on the 5th of September, 2 weeks before the 17th. Why did it come so early, almost 2 weeks before, when we know Parliament was going to be the 17th? And this is almost a couple of weeks after Member Robinson is talking about this dramatic report that was coming to Parliament. How does he know that a report is coming to Parliament?
Yes, the question of, there were two questions. One about the question of the report being sent to Parliament at a certain time. And what was the other question? Oh, the statute of, yes, in relation to the questions being asked of declarants. What I would like, Chairman, is for specific instances to be presented so that they can be dealt with. Specific instances, the name of the declarant and the questions asked, so that the Director of Information can deal with it. The second one, Chairman, you will recall that we were initially invited to attend a sitting here on the 11th of June, 11th of September. If members recall that, then they would not be thinking that we knew that there was going to be no sitting of Parliament until the 17th. And the fact of the matter is that we send reports as soon as they have been received and completed process. We send the reports, and they are usually timed to coincide with a sitting. And our understanding was that there was to be parliament during that week of the 11th of September. And subsequent events, which we have no control over, resulted in the cancellation. That was the date for the nomination in wherever it was.
Chairman, respectfully,
Yeah.
I have to give some guidance in that regard. And unfortunately, your account doesn't comport fully with my understanding of what transpired in the period. I recall that we wrote to you inviting the commissioners for a meeting on the 11th. That had nothing to do with the calendar activities or the plan for the meeting of Parliament. Absolutely nothing to do with the meeting of a committee of Parliament, and that has to do with the Oversight Committee. So we had at no time intended for Parliament to convene before the 17th. In addition, there were some other issues in relation to the preparation of the room and the dining
We didn't know all
downstairs. You wouldn't know that, but it is fair to say that the assumption that because we asked you for a meeting on the 11th, right, which you indicated to us was not possible for the commissioners, but rather the first week of October. And we agreed to do the first week of October. So I regret that you had a misunderstanding in terms of that. But for clarity and for accuracy, the two meetings never had anything to do with each other.
Yes.
The meeting suggested for the committee is a different thing altogether from the meeting of the House.
And in respect of a member of the committee or member of parliament saying that report is going to be tabled or something, I don't think it should be Commission's feet. The fact of the matter is that politicians, as you know, they say things, all sorts of things, they speculate, and we have no control over that.
At this chair, we don't speculate either, as you know. but we do take what is said very seriously.
I mean, a number of parliamentarians, knowing that I sit on the Oversight Committee, have sent me information that especially Mr. Craig Beresford, and you asked for specific examples. I can give you one right now.
And several of them have commended the commission. I can name them.
That's fine, but
Senator Morris.
no, but I don't. I'm not going to call names.
Morris.
No, I'm not going to call names. No, 1 second, Chairman Panson. I'm not going to. But you have a situation now where a member elected in 2020 is asked a question. You bought a 2014 BMW. What is the source of your funds? What's the relevance of that? So we'll ask those questions. Yes. And I can give you many, many examples where a member elected in around 2020 again is asked, what did you do with a car you purchased in the 90s? What price did you get for it, and how did you dispose of the funds? What's the relevance of these questions?
Chairman, if I may, Director Beresford respond. In addition to the need for concrete examples, which I think would be helpful, I believe there are two recurring issues that have been the source of concern that require some understanding. What is the understanding of the IC's remit in relation to matters before the law came into effect? That is one. So the law has a start date, and how far back do you reach under the Act, which had a start date? And relates to inquiries into assets and liabilities before the declarant became a declarant. I said two, but there's also a third one. Materiality and the principle of de minimis. And that is of particular importance against the cost, the administrative cost of pursuing something given its materiality. And I know materiality has to be looked at in context, but across numerous declarants, not limited to members of the political directorate, the recurring questions occur. What is the Commission's understanding of its remit in relation to matters before the law came into effect and in relation to matters before a declarant was a declarant, and materiality?
Thank you very much, Chair, and thank you, members, for your questions. Now, I stand with the Chairman's comment that the specific instances need to be brought to me, and I'm saying this publicly now. The parliamentarians that you see where we're asking questions about source of funds prior to 2018 going back, they need to send that to us. Send that to me, and public officials also. And my email address is craig.beresford@integrity.gov.jm. 1 second, sir. The letter, they should send it to me if that is the case. And let me answer the specific question. The statutory declaration requires you to complete several sections about your property, motor vehicle, et al. Now, if it is the case that you still own the property or you still own the motor vehicle, you have to declare it, even if you purchased it in 1970. On the form, it also requires you to put the purchase price, and there's a reason for it. So if you submit a declaration without the purchase price, regardless of when you purchase the asset, it has to be disclosed. Your declaration is not complete. It is not complete. So the specific issue about source of funds prior, if that is the case, I want you to bring that to my attention, because we have made it clear in our division that if it is purchased outside of a certain period, that we would not ask further questions about it unless there is a special circumstance about that particular declaration that requires us to ask information going beyond special circumstance. And I will not go into the special circumstance because it only happens on certain occasions, specific occasions. But normal course of activities, once we see where you still own the asset or you still own the property, you have to provide complete information regardless of when you purchased it. And it's because the statutory declaration requires it. Yes.
Clarify the point. Insofar as a section of the declaration requires a declaration of the asset and the price of acquisition or disposal, I don't think that is the issue of stating, if one recalls, what the cost of acquisition was. It's the reaching back. So are you saying that your understanding of your remit is that beyond stating the cost of acquisition, you have the power to inquire into the source of funds to acquire that, even if the declarant were not a declarant? Definitely not. I'm happy to hear the answer. You need not say more. I'm just happy to hear that that is your answer, because if the answer were otherwise, something would be very wrong.
I just want to make this clear. We only go back in on this. Yes. Indeed. Yeah. Yes. So once you were a declarant, special circumstances, we may ask questions. But what we do specifically is that we look at each declaration when you procured the asset, liability, if it's income to be declared. We ask for supporting documents once we're reviewing those statutory declarations, as a matter of course. Not happen. And that's why I'm at that specific instance so I can treat with it. It's not supposed to happen.
Well, I think we really have had a very fulsome, yes, discussion. And I just want to make the point that this is the spirit that we want to continue to have very active and very strong discussions between the Parliament and the Commission. There is really no need for us to be angry. That's not the intention. There's no need for us to interpret, comments in the most negative and derogatory way. That's not the intention. The intention together to create the framework and the environment for the strongest and most powerful compliance possible to ensure that Jamaica's reputation and name is strengthened out there as a transparent destination where integrity reigns. I want to thank you, Chairman, and your team for coming. I want to thank members too. We have some small domestic matters to complete before we actually break, but we want to thank you. Word of a phone. Happy hunting. Okay. We have to.
Finish.
Right. So so members we've we've had a very fulsome day. I'm I'm open to the motion for for the suspension of the items that were not covered for the next meeting and for the adjournment. Oh, yes, yes, yes. We will invite them back. We told them that because there are outstanding matters. But what we will have is an interim report to Parliament to indicate that we met, and of course, was a strong call for the review, the urgent review of the laws in relation to, and to recall Member Malahou's point about perhaps a far more comprehensive look at the act itself, overall. And so
10 times better performance can make a big difference. Castrol Edge gives your engine.
we will invite back the. So move, seconded. The meeting is adjourned.
So Marlene Malahou Fort, right? Speaking specifically to the Integrity Commission of 2017 and probing, right, the issue as it relates to if the Integrity Commission investigators, right, are investigating prior to the act, right, came into law. This goes to show that even the very probity of Marlene Malahou Fort is corrupted because you need checks and balance. Because what Marlene Malahou Fort just said right there. Remember that Andrew Holness, as it relates to ADMAT, right? ADMAT created 2008. And ADMAT, you understand, the investigation within ADMAT would explain the source of wealth. The source of wealth. So what is it she's saying? That, okay, the Integrity Commission investigators are not to pursue any crime committed by a politician prior to the act. So then, as we speak as current, if Andrew Holness cannot explain his source of wealth, right, as it relates to where the Integrity Commission investigators stop, are you saying no, that they have no right, you understand, to go beyond 2021 as they are investigating? This is madness. This is clear corruption. Clear corruption. Because the source of wealth, right, as it relates to Andrew Holness, as it relates to illicit enrichment within those prospective years between 2006 to 2009, would have explained in clarity to Jamaican people how Andrew Holness started and how we transitioned as it relates to allegation of illicit enrichment. So Marlene Malahou Fort can't be agreeing, or the Parliament agreeing that, okay, forget the foundation of the crime. Any true investigator is not going to forget the foundation of the crime. Because if you forget the foundation of the crime, how are you going to understand? You understand where the crime begins and where it ends. This is unbelievable in terms of what Marlene Malahou Fort is saying. Marlene Malahou Fort is doubling down in terms of covering up wrongdoing in front of the Jamaican eyes as if we are dunce. So then, okay, where the Integrity Commission start to investigate Andrew Holness as it relates to 2021 statutory declaration, and where Andrew Holness cannot explain the source of funds, right? Because obviously the source of funds as it relates to illicit enrichment did not start at 2021. So don't, Marlene Malahou Fort, don't take the Jamaican people for idiot, right? We are not fools. That you are now going to say then, okay, right, the Integrity Commission investigators are not to investigate beyond 2017, right? Majority of the crime that you are dealing with as it relates to illicit enrichment, as it relates to the allegation where Andrew Holness is concerned, it happened prior to the act. It happened prior to the act, right? So don't go on and try to use your awareness in law and try to pull the rules over everybody's eyes. We are not stupid. We are not stupid, clearly, right? As it relates to illicit enrichment, where the 8 members of parliament involved in, right? Majority of these issues are committed, have been committed prior to even the act. So what you are saying, Marley Malawu, what are you saying indirectly? You are saying that the Integrity Commission must just close the investigation and don't deal with that, and that is one of the reasons why you don't want FID. Now we understand. Now the Jamaican people understand why you really don't want FID to investigate. Because FID, right, is not limited, right, as it relates to how the parliamentarian, you understand, crafted the laws and have limited reach for the Integrity Commission investigators. FID is not limited in that regard. So FID can go back to the original foundation of the crime. Which investigator is going to investigate, particularly when it comes to financial crime, and don't investigate the foundation of crime? I want to ask people in this, any civilized country, Malo Ford, you're a piece of mess. In the United States of America, in UK, in any civilized country, the FBI, you understand, the CIA, all of those entities, investigative bodies, competent investigative bodies, if they are going to investigate any investigation, it has to be with the original foundation of the crime. And so then what you want to do now, Marlene Malawu, because I hear you say it in you actually say it in Marlene. We are talking about statute of limitations supposed to apply. So that means you don't want to get off, you don't want to rob the Jamaican people, them blind, and get off with it. And you're not to be investigated. That is what you are saying, Marlene Malawu. This is what you are saying if a lot of people don't understand. You're going to tell me that an investigator who is investigating a crime, particularly a felony, right? That investigator is not to go back to the original source of the crime, the history. Or you think the United States, when it comes to, serious felony, the United States did up in 10 years, 20 years, 30 years, 40 years. And that's why felony doesn't have a statute of limitation. Get it through your head, Marley Malawu. You're totally wrong. You're Chuck. You're Delroy Chuck. Delroy Chuck is doubling down. Delroy Chuck and Marley Malawu is doubling down in criminality. This is so sad and in front of the Jamaican people. Hold I want to find now Delroy Chuck and Marley Malawu. This is the way how you think that the Jamaicans are so limited in their capacity of thinking intelligently that you can just rub this. No, man. This getting from bad to worse. So then, all of the effort now is to stop the FID from investigating. Let me tell you something. It's going to the judiciary. The judiciary is going to kick out that because these judges are better aware. You understand me? I say, Marley Malawu, you know better, I know. Delroy Chuck, you know better, I know. But again, it goes to show you that, of course, yes, the leader of your administration, you understand, appears to be guilty based on your behavior. If your behavior, right, is to double down, right, and try to protect information and don't want the IC to investigate prior to the Integrity Commission Act 2017, nothing beyond that. They are not to investigate nothing beyond that. When you fully well know, Marley Malawu, that some of the allegations relating to Andrew Holness gone back between the investigation and investigation timeline of the IC between 2006 to 2009. Right? Juliet Holness, big development and lease flat, right? Where that development now has reached $800 million. That's not supposed to be investigated neither. None of that's supposed to be investigated. So what sort of transparency that you want to bring to Jamaican people? What is the level of transparency there? This is how you represent the Jamaican people. That you have members of parliament, right, can pilfer from our treasury, you understand, create Ponzi scheme like SSL, taking the people their money, and there's no investigation. You understand? It's plain naughty that they are supporting criminality. This is no joke. I am so shocked and surprised that it will come out of the mouth of Marlene Malawufo, but we don't expect better. I don't expect any better. You understand? Delroy Chuck and Marlene Malawufo. So I am wondering now, Delroy Chuck and Marlene Malawufo, are you a part of the 8? Because you must be a part of the 8 to defend this.
I'm sure.
You understand? Colonel Charles Jr.
I'm sure.
You understand? Because definitely, you know, this is the kangaroo settings and the entire Integrity Commission, Commission investigators and Jamaican critical thinkers know say this kangaroo setting this morning for only to have the IC. You understand? Have them under scrutiny, have them under probity for what? Who you need to have under probity? Right? It's Andrew Holness. One of the reasons why Andrew Holness, you understand, one of the reasons why the IC Integrity Commission stopped their investigation, you understand, we all know Jamaican, locally and in the diaspora, all know that Andrew Holness have not answered the Integrity Commission investigators as it relates to source of funds. Because he can't answer it. And so then now you know coming now with Agwash committee this morning to drill the Integrity Commission and to inject. You understand? But okay, what I got out of it, what I got out of it, we're going to have to maybe now look into policies, you understand, to do what? To flatten the Integrity Commission and not to strengthen the Integrity Commission. Una some wicked and vicious people. Because what you are saying now, Marlene Malawufo, the entire world hear you now, Marlene Malawufo. Entire hear you and Delroy Chuck. They try to defend criminality, you know, by saying that the Integrity Commission, you understand, should have a statute of limitation as it relates to not investigating crime prior. You understand, to the Integrity Commission Act. You understand, past 2017, because that is out of their capacity. And so then what? The Parliament did not give them the accessibility to do that. So that means automatically weaken the Integrity Commission Act. Weaken certain years of the Integrity Commission Act. You understand? So then, you see, this is so vicious to the Jamaican people. So vicious to the Jamaican people. But guess what? People, later, we are going to tune in as it relates to the IC report that need to be tabled, right? And we are going to follow through that because we know that it is not only Mikkel, right? Situation is there, right? And so then we are anticipating.
But Mikkel is no situation.
Right? And Mikkel's situation is no situation, right? As it relates to him filing his statutory declaration late. That has nothing to do with illicit enrichment. So, you know, we're glad that we flatlined that already, right? So anyway, the report is going to come out and we are going to peruse it for later, right? So we're coming on. Yeah.
So Monica Hall, Champagne is now part of the General Legal Council.
Mm-hmm. Yeah, we learned that a couple of years ago. So the situation is we are coming back out. What time are we coming back out?
1 o'clock in a few minutes.
Oh, so we're coming back out in a few minutes.
Once they start.
Right. Once they start, we'll be here to peruse the tabling of the IC report. So people stand by, and then later on, of course, in the evening, the original scheduled time for Mystic Sensation, we'll be here with Rattigan. We'll be here with Maria, right, to break down the IC report. If it is tabled, don't say that. We will be breaking down that. Elder Fletcher, the IC needs to go into the original foundation of Andrew Holness enrichment. We need transparency. IC, we don't be fooled. We need fairness, truth, and trust. You are so right, Egla. You understand? How are we going to have transparency? How are we going to have transparency if Marlene Malawufo and Colonel Charles and Chuck decided that, okay, they need to craft something, right?
Discredit the
statute of limitation so that the IC cannot look further than where, prior to the IC, the IC Act became law. This is crazy, people. This is crazy, but we have heard it. We have heard it. So why? It goes to show you that this Jamaica Labour Party government is guilty of corruption. Why they don't want, okay, if they are there for checks and balance, transparency, why not say, okay, you can investigate as what you want to investigate. You're not going to find any corruption. But why block that? Why block that? Why block that where the crime, particularly, right? Every portion of the crime committed prior to 2017. It committed prior to 2017. ADMAT, you understand, was not founded 2018. ADMAT founded 2008. So we know where they are going in Martin Foot, and we know that basically what Jan Church is doing is trying to defend Andrew Holness as it relates to the ADMAT situation, the original source of wealth. I know where you are going. Nobody believes we cannot fool anybody. We know that that's the one to protect. You understand? So the Integrity Commission investigators, our field, must not get the opportunity, you understand, to do a deep dive in Andrew Holness, because guess what? Andrew Holness cannot explain it. Andrew Holness cannot explain it. So then, okay, it's best now the Parliament can save Andrew is that now the corrupted Parliament need to, put into law, use maybe them 49 members of Parliament and craft something now where the IC cannot go beyond 2017. What sort of, no, I'm going to ask people, you are asking people to vote for you people? You are, then I want to know, is this what the Jamaican people are really going to vote for? You are going to vote for a government who are willing to, who actually stealing your money, damaging people, creating Ponzi scheme, and this government are not to be investigated, and this same government asking us to vote for them. People, listen to me, they have to pay at the polls. They have to pay at the polls because, let me say this now. We know under the Jamaica Labour Party government here, people, let me tell you something. No justice is going to be carried out. So then, we have to use up our fingers. Listen to what you hear this morning, and decide to take out this government, because we want checks and balance after this government come out, Right? Yes. And we want to make sure so we put in Mark Golden with a strong majority. That means some of them policies where you see them implement now to avoid them from being investigated. Mark Golden can break that down. May I tell you, Jamaican people, no, listen, you want to hear now. You want Marlin Mallow to say that. Right? And we are not misinterpreting what Mallow had said. All of us hear it. That Marlin Mallow is basically saying that crime prior to the 2017 Act created must not be investigated, must not be looked into. Statute of limitation must execute on them. So stay tuned. Next hour we are jump out. You understand? And more beating. You understand?
2 minutes.
Oh, next 2 minutes, then it makes sense to go anywhere.
Well, it's a different one. I have to.
Okay. All right. So people, let me jump off now and then jump on back within the next 2 minutes.
Well, as soon as they start.
As soon as they start, we're going to jump on back, people. So if you don't, Mystic Sensation is here. All right. Blessings, my people.
Okay, guys. See you in a few minutes on the other side.